This incident involving Taylor Meyer occurred, actually, I live up in Norwood now, so this is in Norfolk County, which is the county I live in, and so it was a couple towns over. And I'm going to bring back some of the comments that some of the students made in that little news clip, but let me kind of give you a little history, if I could, on the social host liability statute. This is really kind of where the statute and its current state began. You're looking at the home of John Lennon, not the John Lennon, but a John Lennon of Cohasset, Massachusetts. And back in June of 1996, Mr. Lennon had a daughter who was graduating from, I want to say, Thayer Academy, and they had a son that was also graduating. And he decided that he was going to have a party celebrating both graduations at the house. And so what Mr. Lennon did is he arranged to have a tent set up and some cakes brought in for the parents. It started to rain, so most of the parents went into the house. Well, as you can imagine, most of the kids stayed out back and continued to engage in the drinking of the kegs that Mr. Lennon had provided. Greg Smith was an 18-year-old that was at the party at the time and consumed a fair amount of alcohol at the Lennon house. Mr. Smith got in the car to go home that evening and wound up wrapping himself around a tree and killed himself on the way home. As a result of the accident, you can see, as I mentioned, Mr. Smith died, and several charges were brought against Mr. Lennon. There was a wrongful death action that was brought by the Smith's parents against him. There were some things that were said back and forth during the course of this wrongful death action. There was a defamation action that was brought, and all of that was settled. But what is important and what came out of this particular tragedy was the Smith parents pushed the legislation to try to expand upon the social host liability statute law. And as a result of that, it dramatically expanded the scope of this particular law. And the social host liability statute is up there. It's Chapter 138, Section 34. And at the time, under the terms furnish, the provision you see up there where it says allow to possess was not part of the statute. That particular portion, the allow to possess alcohol, was part of the initiative that the Smith family took as a result of their son's accident. Mr. Lennon was not prosecuted under the social host liability statute because prior to this time, in August of 2000, when this changed, the way it was read, the way district attorneys were interpreting it, the way judges were interpreting it, the way the police were interpreting it, was that in order to be charged with it, in order to try to bring anyone for a conviction under it, you had to actually physically give the alcohol to the minor. And so at that time, Mr. Lennon, basically, there was no evidence that he had physically given Mr. Smith a cup, for example. There was no evidence that he had poured any of the beer for Greg Smith. So there was no prosecution, no violation of the social host liability statute, and the Smith family was saying, you know, that's just wrong. That simply because he didn't give the beer to Greg Smith, that he shouldn't be prosecuted under the social host. So as a result of this unfortunate tragic accident, social host liability statute was expanded in August of 2000. Now Massachusetts then joins almost every state in the Union, there's a couple, that have some type of social host liability statute. The next one. Here you're looking at Brendan Nierman, and again, I'm just trying to give you some history as this statute is evolved and it begins to take some teeth. In January of 2003, so the statute is enacted, expanded in August of 2000, so this is about 3 years, 2.5 years later. Mr. Nierman, who's age 19 at the time, goes to a local liquor store while his parents are away, purchases alcohol, comes back to his parents' house. He and some friends begin to drink the alcohol. A young man named Billy White, who was 18 at the time, was there drinking with them. Mr. Nierman gets the phone call that his folks saying, hey, we're on our way home, how's everything going? fine, Mom, no problem, everybody out. And so everybody decides to leave, including Mr. White. And as Mr. White leaves the residence on the way home, there are two young people walking along the side of the road that Mr. White strikes, killing one, significantly brain injury to the other individual. So Mr. Nierman is brought, charges are brought against him, one, because he furnished the alcohol to Mr. White, who was 18 at the time. And again, here we're going to talk about whoever furnishes the alcohol. And again, allowing it to possess. Again, there wasn't really any particular evidence that he handed the beer to Mr. White, but he allowed the possession of the alcohol. You can see here, this is his reaction in court. One of those, I'd like to take it back. If I could, I would have done so. I'd like to take that time back. He pled guilty to it, and the thought was, well, he was only 19 at the time, so certainly I don't have to worry about a particular social host violation. Well, the judge, on the other hand, did not necessarily agree. In fact, he was sentenced to a year imprisonment, 6 months served, I believe. But what is important here is this particular portion of the statute that the judge wanted to really kind of hammer home, that the wording in it, in the social host statute, says whoever. It doesn't say a 21-year-old who provides alcohol to a minor. It is basically whoever, and it means exactly that. So again, the statute for district attorneys, for judges, is beginning to become more and more defined. This whole notion that, well, if it's a 19-year-old who gets it for an 18-year-old, they can't be, held under the social host liability statute is simply not true. The wording is clear, and the courts have held and ruled that whoever means just that. Doesn't matter their particular age. So essentially, there is a bright line to the law, as we all know. Basically, the next one, there is 21 years and above, it's okay to drink. 21 and younger, it's against the law. I know when I was younger, it was 18, and I know that there was a grandfather clause at one point that made it 19 or something along those lines. But it isn't 20 days and 364, 20 years and 363 days. It's 21 and older, less than 21. It really isn't. It's a very bright line, in other words. Now, one of the things that can happen, you say, well, if there's a violation of the social host liability statute, maybe that might be the be-all and end-all to some sort of criminal violation. And again, I don't do criminal work, but there are certainly other statutes out there that could spring from a violation of social host liability. We put this one up here, and most people go, manslaughter. What do I mean, how is that possible, that you might have a manslaughter criminal charge brought against you for a violation of the social host? Well, this following individual, I'll just put this next one up. This is Alexis Garcia, and in February of 2007, she went over to a friend's house, and the parent of her friend had purchased, I think maybe a liter or a couple liters of vodka for his daughter and his daughter's friend Alexis. And so she decides, and the two children at the house, with the vodka purchased by the father, continue to consume the alcohol at the house. Miss Garcia goes upstairs, takes a shower to kind of maybe sober up before she goes home, slips in the tub face first and drowns in about 1.5 inches of water. Mr. Parent, which I find kind of ironic that that's his last name, was actually one of the first individuals here in Massachusetts to be charged by the district attorney with involuntary manslaughter as a result of his actions in purchasing and supplying the vodka to the minor children. So the notion that it may just be, and I use the word just, a violation of the social host liability, that in and of itself, I mean, there could be another statute out there depending upon what happens as a result of actions. As mentioned, if you go to just the next one, it's like I said, it's just the first recorded case here in Massachusetts. So I think what we're seeing, and when we do a lot of these with other district attorneys from other counties, Essex, Norfolk, Suffolk County district attorneys, a lot more district attorneys are starting to take these particular violations of the social host a little bit more seriously. They're not as likely sometimes to go, well, I've got such a caseload that this is going to fall to the bottom of my list of cases. I can't speak for the district attorney for Nantucket. I know it's Cape and Islands, and I just don't know, working with police, I see a member of the state police here as well, what sort of interaction there is with the district attorney for Nantucket. But this is just kind of an example of, to be forewarned that with the press that is out there, with more and more attention being put on underage drinking and the tragic accidents that happen to them, many district attorneys are pressed to bring these types of particular charges. Another certain criminal charge that one could expose themselves to for providing alcohol to a minor is here in Chapter 119. Again, these are just things that sometimes you don't even think about if you are providing alcohol to a minor or hosting that particular party with the mindset of, I'd rather have everybody in my house as opposed to out in the beach, out in the woods, wherever the case may be. These are certain statutes, criminal statutes, that are out there that are available to both police and district attorneys, depending on what, tragic events may or may not happen following a house party, for example. What we see here is we put up here basically the common scenario that we see. I know that graduation is coming up, prom season. Basically what parents are saying is, look, I know the kids are going to drink, and if I have them drinking here at the house in a controlled environment, I've got better control over what could or could not happen to my son or my daughter or their friends. And we assume then that the behavior and the consequences are going to be predictable because we've got some sort of control over the event. Unfortunately, that's sometimes not what happens. I've got a couple of examples of a couple of tragic accidents, and if you just want to just go forward just a little bit, you can see there again, there's the rationale, there's the assumption that we're going to predict what's happening. Let me show you a couple of examples of what happens. You're looking at Shauna LaRasa. She, at the time, was age 19, and what we're seeing more and more and more are things like, and I never thought I'd be saying this, but kids these days with like the Facebook and the MySpace and the computers and all this kind of technology nowadays have these particular Facebook, MySpace things, and these are from her particular MySpace page, I think, and just some of the things that you can kind of pull out, and if you just go ahead and kind of highlight some. I think pong meaning the beer pong. All of these things were on her particular website that she had out there at the age of 19. And unfortunately, in July of 2009, after a house party, she was involved in a car crash and she died. And one of the things we bring this up is because sometimes parents don't know that these are out there. They don't know about the texts and the Facebook and the MySpace, and it's just a way of saying that there's a lot of communication that's going on amongst all of the kids, and this is a way that they are communicating. David Holman, and that's Shauna there. David Holman was 19. And in July of 2007, he was involved in a fatal motor vehicle accident as a result of drinking. What we find a bit disturbing about this particular case is that he was at a friend's house by the name of Andrew Lesko, who was 21 at the time, went and purchased the alcohol and provided it to Mr. Holman, among others. But what is unfortunate about this one, and you'll see in the next slide, is that not only was Andrew at the party, but Andrew's folks, Deborah and Edgar Lesko, were also at the party, were full aware of what was going on at the party, and in fact, according to police reports and the like, were actually sitting at the table drinking with the kids at the time, and took no steps, certainly, to do anything before Mr. Holman left and wound up killing himself in an accident. And finally, there's a young woman by the name of Elizabeth Munn, and she was at a party. She left the party at the time. There's no evidence that she was actually intoxicated. There was no evidence that she actually even had anything to drink at this particular house party. She wound up walking off into the woods, and they ruled it a suicide. What is interesting about this particular house party is that, if you show the next one, this is the state police that arrived to the house following the death of the woman, and they started to bring out evidence that there had been at the party, because there were a couple of, an 18-year-old and a 19-year-old that had actually wound up purchasing the alcohol and providing it at the party. And again, there's no evidence that the young woman had actually had anything to drink. These two individuals, Mr. Zimmerman, that was the Zimmerman house that you saw the state police coming out of. He pled not guilty to furnishing alcohol to a minor. Morgan, the woman, admitted to sufficient facts in the case, and basically she admitted that she had actually gone in and purchased it with a fake ID. What is, I use the word interesting, is what Mrs. Zimmerman had to say following the particular party. You know, you take away the suicide, and, you know, it was just a small little party being held, you know, it was just a nice quiet party being held by some kids. Again, I take a look at what the police were bringing out, and if we go to the next one, I think they actually kind of, oh, you don't have it there. But let me just tell you what was in some of the bags that they found. They found 20 empty 30 packs of Coors, 3 bottles of vodka, a bottle of Jägermeister, a bottle of tequila, some wine, several beer cans and bottles, various marijuana pipes, grinder, and some other drug paraphernalia. So this is a woman who's saying, well, look, you know, come on, it was just a nice, quiet, small party that these particular kids were having, trying to, I don't know, downplay it for whatever. You're looking at a house here in Wayland, and Billy Sanine is the individual down there on in the bottom corner. One of the things that it's not necessarily going to be an 18-year-old or a 19-year-old that does damage or injury or causes his or her own death. In this particular case, Mr. Sanine had consumed a fair amount of alcohol at this house that you're looking at, and then on his way home, driving down to the Cape, he was 3:30 in the morning, going about 90 miles an hour, and at the time, in the breakdown lane, was a state trooper by the name of Ellen Engelhardt, which you'll see in the next slide right here. This is Trooper Engelhardt. Now, her cruiser was stopped in the breakdown lane, assisting another vehicle, when she was rear-ended by Mr. Sanine at approximately 90 miles an hour. And 90 miles an hour into the back of a stationary vehicle is going to do significant damage to not only the vehicle, but certainly to any occupant in the vehicle. And unfortunately, Trooper Engelhardt was in the vehicle at the time and sustained significant injury. And that's her before the accident, and that's Trooper Engelhardt after the accident. And the reason we do something like this is because this is Trooper Engelhardt when she was at Mr. Sanine's criminal sentencing. And when we're going to talk a little bit about the civil ramifications of what can happen on something as an accident like this, this is a picture to keep in mind if you were a homeowner that Mr. Sanine had left, and if Mr. Sanine had caused these type of horrific injuries to anyone, let alone to a state trooper. Now, these accidents are not just unfortunate ones involving OUI and innocent bystanders. You're looking here at Michael Berry. He was 16 at the time. Now, Mr. Berry had gone in 2003, in December of 2003, over to a home where a number of kids used to go. It was kind of like, if you ever needed to go anywhere on a Friday night, this was the house to go to. And you'd bring your beers with you, and you'd just go down to the basement, and that's the house to go to. Now, the homeowner was aware that these parties were going on. She didn't buy any of the alcohol for any of the individuals. She didn't furnish it. No one took it out of her refrigerator or whatever the case may be. But Mr. Berry was one of several individuals that used to frequent this woman's home. Well, one night, Mr. Berry had himself a little bit too much to drink and was asked to leave because he was intoxicated. Well, on the way out of the house, Mr. Berry, in his drunken state and in his frustration of being asked to leave the party, decided to put his hand through the glass window on his way out. Well, he walks out in December into the cold, bleeding, and they find him the next day dead on the steps of the house next door. Miss St. Jean, who was the homeowner at the time, was found guilty of the social host liability statute in this particular case and was sentenced to 6 months in prison. And that is her there in the next picture. That's, you mentioned, as her daughter was in the sentencing at the time. And then Miss St. Jean was, if you see the next one, this is basically her being taken away to serve her 6-month sentence. Now, you know, we talk about these particular unfortunate, tragic accidents, but these accidents don't necessarily happen outside the home. They don't necessarily happen after the individual or individuals have left and gotten into cars. The next one I want to talk about, unfortunately, is a woman by the name of Meghan Duggan. Now, this was back in 1997, so keep in mind this was before the social host statute was expanded in August of 2000. This is Meghan right here. She was 17 years old at the time, and she went to a house party and hosted by one of her friends, a Mr. Alfred. And she continued and consumed a fair amount of alcohol at the house while the kids were downstairs in the basement. As she was coming down the stairs to come back down to the party, she tripped on this portion of the stairs, fell all the way down the stairs, and struck her head. Her friends at the party thought she had just passed out, so they left her there. They continued the party. They actually continued to kind of step over her. They put a blanket on her thinking she was asleep. The next day, when she didn't wake up, that's when her friends decided that maybe there might be something wrong, but by then it was too late. She had fallen down the stairs and crushed her skull. Police, when they were called the next day to the particular